Hello and welcome to the 8th and final session in our 2021 pick and mix. I don't know if any of you have managed to get through all 8. If you do, there is no prize other than our gratitude and praise. They say that you should always leave the best till last, but we couldn't do that, so we had to get Matt instead. So over to you, Matt.
Thanks, Geraint. Right, this one's quite a short one, so aware as I am, this is the last one of the day. Well, one of the great things about property law, one of the things I love about land law, is that unlike commercial law and other areas of law, it's not just about documents or what was said at a meeting, or it's not just about concepts, but it's also about actual things. Stuff, and who owns things in or on the land can make a big difference. Arguments about ownership of things beneath the surface can make a difference between your client, who may be a developer, being able to get on with their work or not. So I thought it might be at least interesting to take a trip underground in a mini tour of the legal underworld. And as we cross the River Styx, if you like, the starting point when considering what lies beneath is often thought to be the ancient maxim, and I'll try and pronounce this correctly: Quius est solum, eius est usque ad colum et ad infero, which loosely translated means who owns the surface also owns from the heavens down to hell. Now, there's a very learned and interesting examination of that maxim in the 2010 Supreme Court case of Boccardo and Star Energy. By reference to a learned article by somebody called John Sprankling, an American academic, apparently about owning the centre of the earth, Lord Hope of Craighead reminds us in his judgment in that case that in fact it's not really possible to own part of the centre of the earth. According to his lordship, the simple notion that each landowner is the proprietor of a column or cylinder of land that stretches down to the centre of the earth and upwards indefinitely into outer space is plainly no longer tenable. Well, with that dangerous misapprehension out of the way, we come really to the first thing that could really matter for our purposes in the underworld, which is mines and minerals. The relevant point from Boccardo, I know I'm making light of it, but it is relevant. The Supreme Court decision, so far as we're concerned, what it means is that even materials which are very, very deep beneath the surface, in that case, about 2,900 feet below, can be the subject of a trespass claim brought by the owner of the surface. And it's not correct to say that by drilling into those substances, that there's no trespass just because that surface owner has not reduced the materials to his or her possession in the ordinary sense of the word. Now, the point to take from this is this: if materials that are 2,900 feet below the surface can form the subject of a damages in lieu claim, as they were in Boccardo, you can bet your bottom dollar that when you have a developer client who's about to start excavating basement space, there may well be somebody, if they can, who will pop up and claim to own the mines and minerals. So what are the essentials that we need to know about that? It's not just an academic topic, as I say. The first point is that, well, what are mines and minerals? The exciting stuff, the silver, gold, the oil and the coal, has been taken away from ordinary landowners like us and vested in the crown by ancient custom or various statutes. And in any event, not everything that can be dug out of the earth is in fact a mineral. There's quite a lot of law about what constitutes, in any given case, a mineral. In the leading modern authority, applying the test of what is the vernacular of the mining world, mudstone was found not to be a mineral. Crushed rock, on the other hand, can be. By the way, mudstone is pictured there on the top left. And if anyone can guess what the picture is on the top right, then they can put that on the question and answer or the chat function, and we'll have a look and see if there's a winner at the end. Mines and minerals, you've probably really, quite a lot of us will only have come across them when they see on registered titles that they're accepted from the title. And just as a matter of legal curiosity, it might be worth me just explaining a bit about why they're always accepted. In large part, this arises from the old way of holding land, which was the tenure of copyhold. Under that tenure, there was a lord of the manor and then tenants who held under the lord. And under that system of tenure, mines and minerals, or title to them at least, was always held by the lord. In many other cases, under the system of enfranchisement, enclosure, mines and minerals were reserved to the lord as well. And what happened then is in 1925, copyhold was abolished, and the legislation which brought in the modern regime of land law left the mines and minerals where they were with the lord of the manor. So that's just to explain a bit about that. Now, on occasion, I have come across people who have popped up claiming to own mines and minerals by virtue of the fact that they have bought one of those titles that you can get of the lordship of the manor. And it's important to bear in mind, actually, that just because somebody has bought, no doubt in a pub somewhere, the lordship of the manor, does not mean that they get the mines and minerals anyway. They would have to deduce title to that, even though they hold the lordship of the manor. But there's a nice little explanation of how that works, actually, in one of Lord Denning's last judgments in the Corpus Christi case. And then even if the person who owns the mines and minerals does genuinely own them, it doesn't mean that they can come onto your land, your client's land, and build a quarry. And it doesn't even mean, actually, that they can dig down underneath the land and burrow underneath and cause subsidence. There's some quite useful stuff on this, by the way, in the Land Registry Practice Guide. But what it's pointed out there is that generally under the system of manorial tenure, the custom of the manor was that the lord was not allowed to let down the land or to enter upon the land to dig into it. And if you're dealing with an express reservation of mines and minerals in an old conveyance, very, very clear words are needed. So the upshot of all of this is if somebody does come along and say, hey, you can't dig there because they're you're going to interfere with my mudstone or something like that. The question is really, well, the first point is that it doesn't automatically mean that just because they've got some sort of title that they have the right to actually do anything with the mines and minerals. And even then they would have to prove what their title is. But let's say you've got somebody who does clearly have title to mines and minerals. Oh, sorry, by the way, there's one further point. Manorial title to mines and minerals had to be registered in the 10-year period between 2003 and 2013. So that's becoming less of a problem anyway, because after 2013, it lost its overriding status. So on any registered disposition of the land, the rights will be lost in any event. So sorry, when one comes then to the question of what happens if you've got somebody who does own the mines and minerals, well, will they get an injunction to prevent somebody from excavating into the land? Well, the answer is, well, fairly obviously, if it's just a question of your client sort of digging a bit into some sort of shale or mudstone or something like that, the answer is they're not going to actually get an injunction. But are they going to get damages in lieu of an injunction? And the answer to that question is, well, yes, they can. In fact, there's been a recent reported case on that, on a summary judgment application, which I saw on my alerter just the other day. You might then ask, well, is it going to be one of those cases where I have to pay a third of my development profit, under the what people often think to be the sort of starting point under those sort of damages in lieu awards, under what's often referred to as Stokes and Cambridge, but which actually arises from the Rotham Park Authority, which I put on the slide there. And the answer is, well, it's probably not that serious necessarily. In Rotham Park itself, the damages awarded were only 5% of the profits. And in a case where there's almost no harm done at all to somebody who owns these substances in a strata below the ground, you can see that they may well struggle to persuade a judge to give them a full hypothetical negotiating proportion of 1/3. So that's that. The next underground feature that we encounter on our tour of the underworld is pipes. Now, disputes about pipes are an increasing feature of litigation, in my experience. They may well, of course, who owns a given pipe may well make the difference between being able to develop land and not being able to develop land. The first question you might want to ask is, well, who actually owns what when you've got a pipe underground? It's actually quite difficult to find the answer to that, save that there is quite a useful couple of paragraphs in the Court of Appeal decision in the recent Vauxhall Motors and Manchester Ship Canal Company case. That case went up to the Supreme Court on a different point, but there's quite a useful bit of the judgment, goes through a few of the old cases. So essentially, if you remember, when things are fixed into the earth, they become part of the land and then belong to the owner of the land. And that's the case with pipes. The actual pipe itself becomes the property of the owner of the soil. But somebody who's got a right to use a pipe probably has the right to exclusive possession, not only of the space occupied by the pipe, but also of the land just the part immediately below it, in order to give it some support. But that, notwithstanding that there's exclusive occupation, it's still, in fact, an easement. And then just while we're on this topic, don't forget that some bits of some pipes will have vested in a water authority. If you look on my diagram, well, it's not my diagram, I purloined it from the Severn Trent website. I did that, because, by the way, because it's almost impossible to understand the regulations with all the various definitions of lateral drains and private sewers. So these plans are actually quite useful. But if you look at the bottom left terrace house, semi-detached house on the diagram there, the yellow bit of pipe just sort of to the bottom right of the bottom left house, that's a lateral drain because it serves only one house, in other words, the house next door, but it's on somebody else's land. The green bits, they're private sewers. They're on private land and they serve more than one house. So there you go. Now, those bits of pipes, when they vest in the water undertaker under the Water Industry Act and the regulations, that means that if you've got a client who's a developer and they need to be moving pipes to do anything, or to shift them or dig around them or whatever, they are going to have to involve the statutory water undertaker to do that. By the way, matters which arise out of the Water Industry Act and the sort of public statutes to do with pipes and all that sort of thing, are more in the realm of our planning department in chambers than the private lawyers like us. But it's quite regular now that I'll be in a conference with one of the planners. So in particular, my colleague Ruth Stockley and I quite regularly advise on pipes and ransom strips and all that sort of things for developers, where Ruth will deal with statutory rights to get services in and pipes and highways and things like that. And I deal with the easement type issues. So the next feature we then come to in our tour of the underworld is a septic tank. And staying with the question of who owns what with a septic tank, if I have a septic tank which I use, which is on somebody else's land, the question may arise is whether I'm in possession of their bit of land where my septic tank is situated, or whether it's just the right in the nature of an easement to use it. And that could be relevant for all sorts of reasons. It's relevant for a remedy if somebody's messing around with your septic tank. Is it a trespass or a nuisance? It's also relevant, of course, if after a certain amount of time, if it's unregistered land, particularly after 12 years, whether you could get adverse possession of the land in which you are using and occupying as a septic tank. Now, there's no case on this, and in a recent trial that I did, I had to sort of work from first principles. The only case I could find was a really old one from 1828, which was about a burial vault. And I reckon that if a burial vault was only the subject matter of an easement, which is what the case decided, then probably a septic tank is as well. So the right to use a septic tank, probably an easement. By the way, in that 1828 case, what had happened was that a rector of a parish, I think it was in Hastings, he sold for 20 guineas the right to use a burial vault, and then pocketed the 20 guineas and then put another corpse in there as well, thus depriving the payor of the exclusive right of using the vault. The point that had to be decided by the court was what sort of right it was. And they decided that it was actually an easement and therefore it had to be in writing. And seeing as this poor burial vault buyer hadn't got his contract with the rector written down, probably thought he didn't need to, given the circumstances, given that you think you could trust somebody in that position, that it offended against the statute of frauds and they had no right at all. So anyway, that's that one. Prescriptive rights with pipes. Again, if you've got an express right to use a pipe on someone else's land, all well and good, it's much easier. But there may well be circumstances where your client, for example, if they're wanting to develop land on plot A and they need to use an existing pipe that goes through plot B to get to the main sewerage system, they need to rely on prescriptive rights. Now, we all know, and I think that Paul was dealing with this a bit before, that 20 years open user is enough to get you a prescriptive right, but therein may well lie the difficulty, because with it being underground, is it not therefore not open, i.e. clam, the requirement being for it, of course, to be neck clam. And the key authority on this is another nice old case, the Union Lighterage Company and London Graving Dock case. Now, what happened there was that the defendant had wanted to be able to have rods which went underground in order to pin back his dry dock. And the rods went underground through the plaintiff's land, and they were only visible on the side of the wharf by the presence of these big bolts. And in fact, the plaintiff's engineers had seen these bolts and knew what they were. But of course, the fact that they had actually seen them didn't make any difference. It was the question was whether a reasonable person looking at those bolts would realize that they betokened underground tie rods in the land. And in fact, it was found that it wasn't obvious enough. So the question there is whether the owner who is diligent in the protection of his interests, this is Lord Justice Romer, would have the opportunity to find out. So coming back to the pipes then, you're okay, in my experience, if the house or the property that's being drained obviously needs to drain somewhere, and it's obvious that their pipe must go through your land. But otherwise, there can be arguments about this. So that's one way that prescription can cause difficulties with the use of pipes. The other reason why it's much better to have an express right to use a pipe is to do with the rights of entry and repair. With either express or prescriptive rights, you've always got the right to go on and repair the pipe. And that's from a really old case, Pomfret and Rycroft from 1668. I would tell you the facts, but the language was so old that I didn't quite understand what was going on, other than it was something, I think, to do with a water pump, which had become bechoked and befouled, etc., etc. And the plaintiff was trying to assert a right to go on and repair it. So if it's either prescriptive or express, there's no problem. You can always go on to the servient land and make good your grant by doing the works. There's also, by the way, the right in appropriate cases to stop people building over the pipe, which in a way which will prevent you from exercising those rights. Now, the cases that have decided that, they tend to be big water main type pipes under statutory easements. It's questionable whether you get an injunction to stop somebody building a house over a little drain. But nevertheless, just be aware that it is possible in the right case to protect your right to repair a pipe by injunction. For an express right of drainage, there's probably a right to upgrade the pipe to meet modern circumstances. So if you've got like a knackered old clay pipe, you're probably perfectly entitled to go in and change it to a plastic one to increase its capacity if there's an express grant, but not so in the case of a prescriptive grant, because upgrading is, as opposed to repairing, isn't allowed when you've only got a prescriptive right. And the other reason why prescriptive rights are less attractive is that they're subject to the law about changing the use of the dominant tenement and also increasing the burden. The scope of a prescriptive right, as Paul was saying earlier on, has to be determined by reference to what's actually been done. So in the McAdams Homes case, I think it was a bakery being turned into two houses. And the trial judge found that that was such a radical change in character that it meant that the new use was outside the scope of in fact, it was an implied grant in that case, but the judge said, it was Lord Justice Neuberger, said that it didn't make any difference between implied and prescriptive. The law was the same. But that was too much of a radical change to be allowed to rely on the rights which had been acquired. So you're subject to the argument potentially that if there's a radical change in the character of the dominant land, and if coupled with an increase in the burden or substantial increase, then you can't do what you want to do. So for instance, if you've got a few old farm buildings, and there's a prescriptive right, say for those to drain some effluent and some surface water through a pipe, you can't then go on and probably drain 10 times as much water and effluent from a modern housing development. You probably could under an express right, but not under a prescriptive grant. So that's that. Then finally, it's hardly a highlight to end on. I mentioned before about these things becoming increasingly common as a subject of litigation. They're rather unremarkable status in life generally. is rather is not in proportion really to their importance in terms of whether you can do things with land or not, though. Septic tanks, you've probably heard of the general binding rules. It's an absolute devil to find where those general binding rules actually emanate from and what they say. But essentially, I've done the work for you if you want to keep that slide. They're from the Environmental Permitting Regulations 2016. What's happened is that under those regulations, to do I think it's called a permitted water discharge, you need a permit, but not if it's an exempt permitted water discharge. And the classes of exemption are set by reference to essentially rules that are made up as they go along by the Environment Agency. So it's almost like secondary legislation. And they keep changing. And one of the things that they've said in the general binding rules, for example, is they originally set a deadline of January 2020 to upgrade a septic tank which drains directly to a stream into a small sewage disposal unit. And then that deadline was put back. So you have to look at the most recent version of the general binding rules. They're on the government website. If you're ever dealing with them in a pleading or anything, the source of them is here. It's frankly so boring that I don't want to go through it all. Practically speaking, though, if your client needs to upgrade from an old septic tank, i.e. one that I've pictured there, to a nice new disposal unit, you're going to need to decide whether they've got the right under the grant that they've got to do so. One of the big differences is that these new units require electricity. And so you're going to have to look at your grant to see whether it's ample enough in scope to accommodate the new system. I suspect they probably will be. I can't find any reported authority on it. But again, when somebody comes to sell a house, this sort of thing now assumes great importance because the regulations say that the buyer and the seller have to agree responsibility for who's going to do the work. So anyway, sorry to finish on something which is a bit bog standard, if you'll excuse the pun. I hope you've enjoyed my brief little foray into over the River Styx and into the underworld. Just to sort of conclude then things like mines and minerals, whilst you might not need an absolute in-depth knowledge of them for all purposes, you do at least need to be aware of what's going on and where to look it up. They're not just arcane academic issues which only arise in textbooks or for big firms doing oil law or whatever. It can rear its head. And when you're thinking about the property that your client is buying, just in general, remember to be aware that it extends downwards. And even if it's not, as it may be tempting to think, and contrary to what Lord Hope said, to the depths of hell itself. So that's all I've got to say. Sorry, I went over by 10 minutes. I was only supposed to be 20 minutes. Are there any questions?
Yeah, thanks, Matt. That was great. There's a couple of points that have been raised. There's one raised by Catherine about registration of mines and minerals, and I've dealt with that. Director Catherine, I hope that answers your question. Yeah, you say that, Matt, but David Jones has asked whether it's worth mentioning the significance of ownership/possession in former copyhold. Now, I don't claim to be an expert in copyhold matters. I don't know if you do.
Well, when copyhold was enfranchised, what happened was copyhold was one of the pre-1926 tenures. Even prior to 1926, those who held copyhold under a lord of the manor could enfranchise and become a freeholder. In 1926, there was a statutory enfranchisement, and for the purpose of mines and minerals, the the title to those was left where they were with the Lord of the Manor. I'm not quite sure whether that answers the question. I mean, if there's a particular aspect of possession under copyhold, then I'm quite happy to think about that if we want to. If David, is it David Jones? You say, Geraint?
Yeah.
Hi, David. If you want to just email me about any particular issue, but I mean, it has to be said, it doesn't raise its head much now for obvious reasons. But that's essentially how it works. Anything else?
Well, one from me is just to point out how wonderful it is that we live in an area, or we deal with an area of law where we can go back to 1668. And while you were on, I found out that that was the year that Isaac Newton got his MA from Cambridge, which is ridiculous. But Richard Bingham has left a question saying, just going back to the point of a burial chamber being an easement, how can this be? What would be the servient tenement in such a case? I suppose it's easier to see in the septic tank, but with the...
Well, yeah, I agree. It doesn't really fit in that well with the idea of possession. But then again, it kind of falls a bit between the two, really, I think, because you wouldn't normally think of being in possession of a septic tank. I mean, I don't want to be too sort of lavatorial about it, but the servient tenement, I suppose, is just the land in which the burial chamber lies. And you come to those difficult questions about having exclusive possession of areas of that land. Is it so much as to offend the ouster principle? The ouster principle seems to be going out of fashion a bit. There was that Scottish case, wasn't there, about parking? The one, Scott and Moncrief, I think it's called.
Yeah.
So yeah, I think the servient land would, I suppose, be the churchyard, I suppose, in that instance. Just as the servient land, if you had a septic tank, would be the garden or piece of land in which it sits. But these things, they are rearing their head a lot more. And the other thing is, people doing backfield development, they find quite often that there is a septic tank there, and clearly they don't want it to remain there if they're going to be building a nice house on the land. So it's increasingly a feature, I find it, rather mundane and unglamorous though it may be. For some reason, the clerks always give me this type of work. I don't know if you've noticed that, Geraint. It's like anything involving sort of, well, I won't say what, just tends to come my way. There we are.
All right. Well, I think that's everything now. Given that we've gone beyond, I think it's probably time to call it a day. So thanks very much for that, Matt. That was really good. Thank you to everyone for attending. Hope you've enjoyed this one, and if you've attended any of our other ones, hope they were good for you too. The notes are available as a PowerPoint download on the chat function. Otherwise, they're going to be sent out to you all. The videos will be available on the King's Chambers YouTube channel, which I feel very cool saying. I'm not sure quite when they're going to get uploaded, but keep an eye out for those if you want. Thank you very much, everyone.